That brings us to the next phase of your case, the discovery phase. It's called discovery because it's where both sides discover what evidence the others have. It can take 6 to 12 months, and the reason why it takes so long is everybody has got busy schedules to juggle, including you. Discovery comes in two parts. The first is written discovery, where the parties send each other written questions called interrogatories, and they also send requests to produce evidence. Once that aspect of the case closes, you move to the second part of discovery, which is called depositions. That's out-of-court sworn testimony, usually done in a lawyer's office. There will be a court reporter there who takes down your testimony just like you were in court, and you'll be under oath. Depositions are used by the parties to figure out what each side will testify to at trial. After depositions are done, you move to the mediation phase. Mediation in this situation is required by court rules before the case can go to trial. This phase usually takes 60 to 90 days because, again, everybody's busy and we've got to get on the schedule of a busy mediator. The mediator is a neutral lawyer who's not involved in the case, but who has a lot of experience in nursing home cases, who can help both sides settle the case. At this phase, mediation is usually called full-blown mediation because this is where both sides make the strongest effort to settle your case. For me, that includes sending a detailed summary of the strengths of our case to the mediator. And unlike some lawyers, I also send it to the other side because there's no better time than now to let the other side know where you're coming from, because that, in my experience, is going to give you the best shot at a successful settlement at mediation. Mediation doesn't always work. When it doesn't work, you go to the final phase of the case, or one of the final phases of the case, trial. Cases are usually eligible for trial in South Carolina, depending on where you're filed, anywhere from 18 to 24 months after the lawsuit gets filed. When you go to trial, costs skyrocket because we pay our experts to get ready to testify, and we've also got to pay treating doctors to give a deposition to be used at trial about the injuries. While we're getting ready for trial, we are preparing the evidence that we're going to present. We're preparing our witnesses, including you, to testify, and we are preparing our counter arguments to the defense evidence so we can overcome it at trial. When the case finally gets to trial, here's how a trial works in a nutshell. The first part of a jury trial is jury selection. Both sides try to select people as jurors who are going to help their case and exclude the ones they think will hurt their case. 12 jurors get selected, and then probably a couple of alternate jurors just in case somebody gets sick. After the jury is sat, you move to opening statements. That's where both sides tell the jury what they aim to prove. Then we move into the presentation of evidence. We go first. We present our witnesses and evidence, and the defense gets to cross-examine our witnesses. Once we rest our case, the defense starts their case. They present their witnesses and evidence. We cross-examine their witnesses. Finally, in the trial, it moves to closing arguments. That's where both sides summarize the evidence to the jury and tell the jury why they should win. Following that, you've got some of the most awkward moments in the trial process, jury deliberations, while you're just waiting around for them to make a decision. After that, you have the announcement of the verdict. When the verdict comes, it ain't nowhere near over sometimes. You can still have post-trial motions to undo the verdict, even if you win. And even if you win, there may be an appeal that can stretch out for years. The good thing about trial to remember is it can still settle at any time. Well, folks, that was a lot. I thank you for sticking it out with me, and I'm going to leave you with one thing. You need to know facilities fight these cases tooth and nail. And if you try to go it alone, you're going to be an amateur in a sea of professionals between facility administrators, insurance claim representatives, and defense lawyers. There's no way around it. If you've got a nursing home neglect or abuse case, you need professional help. Find a lawyer you trust to help you and your family. I thank you for thinking about this with me, and I hope I see you soon.